Hello, this is the AI Lab. Today it's my pleasure to welcome Mark Lemley. Mark is William H. Newcomb Professor of Law at Stanford Law School and the director of the Stanford Program in Law, Science and Technology. He teaches intellectual property, patent law, trademark law, antitrust, the law of robotics and AI, video game law, and remedies, and he is the author of 11 books and 218 articles. The reason? An article entitled How Generative AI Turns Copyright Upside Down. Let's hear what Mark has to say. So, in your article, you discuss how generative AI challenges traditional copyright doctrines like the ID expression dichotomy and the substantial similarity test. Can you briefly explain what these doctrines are for non-specialists and how you envision they might evolve to address the increasing role of AI in creative works?
Sure. So copyright law has always tried to protect creative expression, but it's worried about giving too much control to authors. And so it is careful not to protect the idea behind a work, right? We want many people to express those same ideas in different ways. And so we call that the idea expression dichotomy. And what generative AI does is it changes the normal economics and the normal dynamics of creation. Now, the stuff that used to take the hard work, making the painting, doing the actual brush strokes, right, generating the expressive content, is the stuff that's done for us automatically. And that creates a problem for copyright law, right? Because if we don't protect your idea, and copyright law, at least so far, says we won't protect expression if it's created by the AI rather than by the person. Then the question is, well, what, if anything, is there that copyright might protect? And the answer is not entirely clear, but maybe there's a kind of thin line somewhere in between creative expression and writing the prompts that enable you to demonstrate this. So the first issue, I think, is we've got this sort of question of what, if anything, is there to copyright. We've also got a second problem of how do I know whether somebody's copied what it is that it is creative about my work? And that's where this substantial similarity idea comes in. When we fight about copying in copyright law, if the defendant doesn't say, well, I admit that I copied, we will infer copying if the works are sufficiently similar. Because we think, well, you probably wouldn't have independently generated something that close to what the plaintiff did. But I think generative AI blows that up too, because it's no longer clear, right? On the one hand, right, whether two works that are similar must have come from the same prompts, from the same source, or just the AI decided to make the same thing. But the converse, I think, is also true. I might in fact copy your prompt, put it into a generative AI and get a different output. I did copy from you, but now similarity is not going to be evident.
Yeah, that does create some challenges, I imagine. But I'm sure copyright lawyers will find new things. In the article, you also suggest that the role of human creativity may shift towards asking the right questions or structuring prompts, as you mentioned. Do you think this shift will lead to new forms of legal recognition or legal protection for prompt engineering?
Yeah, I think it's probably the way the law will ultimately go. I mean, so we're still litigating these questions of whether or not the material actually generated by the AI could be copyrighted. And it may be that we ultimately say yes. We had a similar issue come up 150 years ago with the development of photography, right? And early courts said, well, the machine took the picture, right? No human took the picture. There's no human creativity. But the Supreme Court in the United States ultimately said, yeah, but there's human judgment that goes into what do I point at, right? In early photography, a lot of it was a setup, right? You have to pose this, the subject, you have to do the lighting, you have to decide on the exposure. And so we concluded that we would give you copyright protection, even though the machine actually made the image, because you did those things to sort of help determine what the image was going to look like. And I think we may do something similar in generative AI, right? Where even if the machine is the one making the image, courts will get more comfortable with the idea that the way I structured the prompt, the way I iterated it and came back and asked questions could itself be creativity that's leading to output. I don't think that will always be true. Sometimes I just ask a very simple question. I just give the idea. And if that's right, I'm not sure there's any protection. But I think we may well see, as prompt engineering gets more sophisticated, courts comfortable with the idea that there's creativity there that we ought to protect.
Yeah, when you mentioned photography, that made me think, I wonder what will happen when a monkey will start using AI, as we had the case with photography. That's going to be an interesting one. Now, given the complexities of establishing authorship in AI-generated works, and as you mentioned, some prompts are sophisticated, some prompts are quite basic. Do you believe there is a middle ground for balancing the human contributions and AI outputs within the current copyright frameworks, or do we need an entirely new set of legal categories?
So I think we can find that middle ground. And one of the things I suggest in the paper is, right, I think that maybe that something around the creativity of prompts will matter. But I think we're not there yet. We don't have the sort of case law to sort of set that out. And I also think that middle ground, if we find it, is going to look rather different than what the copyright industries are used to. Right. So the assumption that, well, I made a movie, I made a video game, right, I wrote text, I get copyright in that work. That assumption, I think, is going to be called into question in the generative AI context. There may well be things you can protect, right, that stem from the creative choices you made in prompting, but it might be far less than people currently get and far less than they expect. And I think it's going to come as a shock to a movie studio or a video game company, right, that decides to save money by using AI to generate its backgrounds, that other people might be free to copy those backgrounds, right, even if they can't copy the whole movie. So there's going to probably be some pressure to try to change the law to bring it back to something that the copyright industries have been more comfortable with. But for now, I think, even if we get copyright protection, it's going to occupy this sort of weird middle ground, and it's going to feel very different than what we're used to.
Thank you, Mark. That's really helpful. I see your point about the copyright industry not being happy if that were the case and probably reacting. Who knows, maybe Mickey Mouse will come back under copyright yet again, or at least the one that came to the public domain. Yeah, I think although there are differences in how the US and the EU look at copyright, I think probably those challenges will be the same and will need the same conversations to happen. So look forward to you continuing to contribute and reading you. Thank you so much.
Thank you.